Informed consent and medical malpractice laws. People in Western Pennsylvania visit doctors for various reasons, from routine checkups to serious medical procedures. Every medical treatment carries some level of risk, which is why informed consent is an essential part of patient care. When a doctor fails to provide necessary information before a procedure, and harm results, it may be considered medical malpractice. Informed consent means that a doctor must fully explain a procedure, including its risks and reasonable alternatives, before obtaining a patient's agreement. If a doctor does not properly inform the patient and an injury occurs, the patient may have a legal claim. However, for a malpractice case to succeed, the patient must prove that they would not have undergone the procedure if they had been fully informed. Negligence and malpractice are often confused, but malpractice specifically involves a breach of a professional duty that causes harm. When is informed consent legally required? Under Pennsylvania law, informed consent is required for medical procedures that carry significant risks. According to Title 28, Chapter 103 of the Pennsylvania Code, doctors must obtain voluntary agreement from a patient after explaining the procedure and its potential consequences. Procedures that require informed consent include surgery, anesthesia, chemotherapy, radiation therapy, blood transfusions, and experimental treatments. If a doctor fails to obtain informed consent, they may be held liable under Pennsylvania's Medical Care Availability and Reduction of Error (MCARE) Act. However, a patient must show that they would have declined the procedure if they had been fully informed. The law follows the reasonable patient standard, meaning the court will determine if a typical patient would have made a different decision based on the missing information. Key elements of informed consent include a clear explanation of the procedure, its purpose, and the expected outcome, a discussion of risks, complications, and benefits, presentation of alternative treatment options, the right to decline treatment, and an explanation of potential consequences, anticipated outcomes, including recovery details, identification of the medical professional performing the procedure, an opportunity for the patient to ask questions. Physicians in Pennsylvania are legally required to obtain informed consent directly from the patient. The Pennsylvania Supreme Court reinforced this in the 2017 case of Schinell v. Toms, ruling that doctors cannot delegate this responsibility to their staff. There are some exceptions to informed consent requirements. In emergency situations, when a patient is unconscious and immediate treatment is necessary to prevent serious harm, doctors may proceed without formal consent. However, in all other cases, failure to obtain informed consent may lead to legal consequences. If you or loved one suffered harm due to a lack of informed consent, the medical malpractice lawyers at Luxenberg Garbett Kelly and George P.C. can help. Our law firm has a strong history of securing substantial settlements and verdicts for our clients. Call 724-658-8535 to schedule a free consultation. Our office is located at 315 North Mercer Street, New Castle, Pennsylvania, 16101, United States.